have to watch for that. Could we shift gears now, Joy, and tell us a little bit about what the defense had to say in their opening statement?
Yeah, well, so the defense actually took some of those comments and really kind of flipped them on their head, saying that because these victims, particularly in the case of Lindell Lewis and Gloria Jean Hart, because they had individuals involved with drug use and abuse in and out of their home, individuals who had owed money and so forth, that opens up a whole realm of other possible suspects who had motive to kill this couple who was in their 60s at the time, and really went with this theory. The defense really went with this theory of confirmation bias, that that investigators essentially had in their minds that this defendant was responsible, and so zeroed in on him and ignored that there are so many other possible suspects out there.
I think it's often that's what a defense alleges, right? It wasn't him, it was someone else. So again, we're going to watch that unfold. Joy, you're staying with us. I also want to bring back my guest, former federal prosecutor Neama Rahmani. Also now joining us, criminal defense attorney Melanie LaGrone. Melanie, if I could start with you. One of the things that Joy mentioned, and she and I were communicating a little bit earlier, it's an interesting fact, is that this venue, this crime scene that the jury got to walk, is only 3 miles away from the courthouse. And there was a motion filed by the defense earlier on asking for a change of venue because they are literally pretty much in the same neighborhood as where these crimes occurred. That was denied. The motion for change of venue was denied. They are still here trying this case. What are your thoughts about being so close to the crime scene, if anything?
Well, I would definitely have obviously as a defense attorney preferred a change of venue, just for the simple fact that, one, with it being so close, but also two, that the neighborhood, it sounds like, nothing like this has happened in, years, I guess, in this particular area, and that it was a close-knit neighborhood, so that it would be really hard to find impartial jurors. But apparently, the judge didn't see that. So the venue is going to remain the same.
All right. And Neama, if I could ask you, please, talking about a defense of other suspects, it is an argument that you hear in a lot of different trials, which is the defense puts up a defense to say it wasn't him, it was somebody else. In this case, what, if anything, sticks out to you as a potential problem or win for the defense?
Ashley, it's what we typically see in these cases when they don't have a good defense. Go after law enforcement, sloppy investigation, rush to judgment. Just like Melanie said, try to change the venue because this is a tough case for the defense. I mean, what they wanted to do is negotiate with the prosecution, take the death penalty off the table, and their client, Ford, wasn't having it. I mean, so much so that the judge ordered a competency hearing. So here you have a particular defendant who is running the show. He does not want any deal, and that's why this case is going to trial, because he absolutely maintains his innocence, and the defense is going to have its hands full because this wasn't just the first or even the second. This is the third arson that this particular defendant is charged with, and there's going to be a lot of pressure on these jurors to convict.
And you are right, Neama. I'm glad you brought up the fact, just to share with all the viewers, is that, yes, they did make a motion to have an evaluation to find out whether or not he was competent. And it did. There was some report coming back that said that he did have some brain damage, some dementia. However, the judge did deem him, after having hearings, hearing the evaluations that Ford didn't want, by the way. He didn't want those evaluations. The judge did find him competent to stand trial. All right, Joy, could I ask you, please, tell us what you expect next in terms of witness testimony that begins tomorrow?
Yeah, so we expect to hear from some of the neighbors about the defendant's remarks to them and the defendant's behavior. But one of the most important witnesses that we expect to hear from, post-mortem actually, is Thomas Hughley. The prosecution has said that told the jury today that they will be hearing from Mr. Hughley, who survived the fire but then went on to pass away due to other causes. And presumably that would be introduced in the form of prior testimony. But that is certainly expected to be a key part of the prosecution's argument.
This isn't a case that, I mean, there's so much emotion. When you have 9 victims who died in 2 different fires, including 5 children, the emotion's there. You already have the jury. You almost don't have to say anything in opening statements to know, in terms of the prosecution, that the emotion is there. This is a terrible case, terrible outcome. So if I could ask you, Melanie, I want to shift gears and talk about the fact that you do have an individual, as Joy just pointed out, that is going to testify as a prior statement, so that they're going to have to listen to it. Is it harder to get a jury to really pay attention and listen to testimony when it's not a live person sitting there, in your experience?
In my experience, Judge Ashley, I don't believe so. As long as it's, very clear, and they can follow it, it usually is not, it's not hard. Jurors will continue to be focused on what they're listening to, pay attention to it, and really try to dissect it to see if it makes sense and if it's relevant to the case and has some, sort of, if it's going to help the outcome, what they want to decide in the end.
And Joy, one of the other things, and you've worked on an incredible, what we call an anchor memo, because it has so many of the law and the facts and the details behind this trial based on all of your investigative reporting. And one of the things I want to share is, in order to ask for the death penalty, certain criteria have to be met. Certainly all crimes are not something that the death penalty can apply to. And in this case, as I understand it, what the state did in Ohio is, in part, say, for instance, repeat violent offender specification, and then also adding some other grounds. But what do we know in terms of his being a violent offender? Is it because of these 3 particular crimes, or do we know anything about his past criminal history?
Yeah, I mean, there apparently were other offenses on his record prior to these violent crimes, but it's really not clear how much of that the jury is going to get to hear. As you know, Ashley, being a judge yourself, that there are evidentiary rules as to what can be introduced regarding those prior convictions. So that's something that remains to be seen as well.
All right, Joy, always appreciate your excellent reporting. I know you're going to be there live in Ohio, but you're going to be leaving us at this time. Thank